Hi everyone, you watching the virtual amicus and I'm Jay Ludha. So today's topic for discussion would be on operation and mismanagement under the provisions of the Companies Act. Now, what is the difference between oppression and mismanagement? Which are those acts that are classified or held to be oppressive? So is it not calling a general meeting and keeping shareholders in the dark? Does it qualify to be an act of oppression or non-maintenance of statutory records and not conducting affairs of the company in accordance with the provisions of company law, or depriving a member of the right to dividend or refusal to register transmission under will? And which are those acts which are not classified as oppressive? How does one prevent oppression that is happening? Where is the remedy available? Is it before the company law board or is it before the national company law tribunal? And how does one approach it? Under which section can we move an application, or a shareholder or director of the company who's faced operation? How does he remedify the loss that has happened to him or the interests that have been prejudiced against? Who can apply? Who is eligible? And what do we mean by mismanagement? How different is it from oppression? Are when the affairs of the company that are conducted in a manner that are prejudicial to the interests of the company, does it qualify to be mismanagement, or there's an immaterial change? Which acts qualify to be the acts of mismanagement? Where does the remedy lie? So, and who all cannot apply and who can apply? Who is eligible for the remedy that is available under the company law? So, to elaborate further, we have with us a very special speaker. He joins us from Bombay. We have with us the amicus for today's session, Mr. Nikunj Mehta, advocate, Bombay High Court. Mr. Mehta pursued his law from Government Law College, Bombay, in May 2013. Currently, he's working as a counsel in the chambers of Senior Counsel, Mr. T. N. Subramaniam, from June 2013. 5 years and 8 months of work experience he has carried on. And before joining counsel practice, before he started litigating, he had interned at Jay Sagar Associates, PDS Legal, Kang and Company in direct tax law practices. Now, as far as his specialization areas are concerned, he's done civil, commercial cases before Honorable Bombay High Court, Bombay City Civil Court, various arbitral tribunals, where he has dealt with suits, arbitration arising out of contracts, pertaining to recovery of money claims, claims for damages, specific performance, immovable property related cases, admiralty cases, minority majority shareholder disputes, winding up petitions, and various other testamentary suits, civil writ petitions, public interest litigations. And he's also appeared in various diverse fields of litigation, such as sports, where a board of cricket control in India's litigation with the IPL franchisees, media, television, channels litigation with TRP agencies, environmental public interest litigation, and particularly with respect to waste management in Mumbai, and other cases which are pertaining to immovable properties, flat sale transactions, etc. And he's also been briefed by Motiwala and Company for Bombay Port Trust in a suit presently before Bombay City Civil Court. And so thank you so much, Mr. Mehta, for taking out time on a busy working day. And the stage is set. The floor is all yours. Over to you, sir.
Thank you, Jay. Thank you for a exhaustive introduction. So I'll try to answer all your questions. But by and large, we must keep in mind that if you've seen one majority shareholder, minority shareholder dispute, almost all of them are more or less the same. The range of disputes is the same. The scope of jurisdiction of the NCLT is the same. So let me just start by referring to the sections. So under the old Companies Act, that is Companies Act 1956, this was sections 397 and 398. In Bombay, it was referred to as a 397, 398 petition. Both they pertain to oppression and mismanagement. Under the new Companies Act, that is Companies Act 2013, this is sections 241 to 246. Most of the case law is under 397 and 398, sections 397 and 398. And of course, recently you had the landmark judgment in the case of Tata Sons, where you had Cyrus Mistry and the Shapurji Palunji Group, which is a shareholder in Tata Sons Private Limited, who had alleged oppression and mismanagement before the NCLT in Mumbai, where they lost. In appeal before the NCLT, they succeeded, but then again the NCLT's judgment was reversed by the Supreme Court. So ultimately they lost. But that is a landmark oppression and mismanagement case, and it's a contemporary case which I think most law students and followers will be aware of. sections 397, 398, and 241 and 246 of the new Act, they are more or less similar. The case law and the precedents which applied under sections 397, 398 should also apply here. There are slight modifications, but unless it's very fact specific, we need not really go into those modifications. So having referred to the section, let us now see what the principle is. What is the principle of oppression and mismanagement? Basically, the test is one of fairness. So all shareholders should be treated the same, subject, of course, to them being preference shareholders, or those where they've invested more, the returns will be more. But by and large, in principle, all shareholders should be treated equally. It should not be that a group of shareholders, by virtue of being or by virtue of having control of the management of the company, can take decisions which benefit them to the disadvantage or to the prejudice of the minority shareholders or of the shareholders who are not in control of the management. So in a way, although this is not a entirely accurate comparison, but in a way, this is like the section is like a check on the powers of the management of the company. Now, you would think that the management of the company is obviously appointed by the majority shareholders, but there are cases where the 51% majority shareholder has not appointed the management, and the management has been appointed by other shareholders, and the 51% shareholder is alleging that their rights have been affected. Their rights have been affected in an unfair manner. So the issue is not really of majority minority. The issue is also of who is in control, who is the management. So here we must have the company. We must make a distinction between the company's management, which means your managing director, which means all your executives who who run the company in a day-to-day manner, who run the business, and then you have a board. Now the board of directors is supposed to be a different institution, which is supposed to act like a check and balance on the power of the management. The management should report to the board, and the board should ensure that whatever the management has been doing, the day-to-day decision making it has been doing, is in the interest of the company. So therefore, it is very important from a third person point of view. It's very important that both these distinct entities, that is the management of the company and the board of the company, both function as envisaged under the law. Now, just think of the board as, in a way, judicially keeping a check on the executive. So similarly, the board should, obviously not to that degree, but the board should have some amount of check on the management. So therefore, now the management which is in control of the company has a lot of power, obviously, to take all kinds of decisions. Now, by and large, all businesses internally, the relationships are based on trust, and beyond the point of there's a breakdown in trust, then every act looks suspicious, and if the trust is there, then even the most every sort of action of the management passes. Now, what happens usually in a minority majority shareholder dispute is that the management in control, which is mostly appointed by the majority shareholder, although there are, like I said earlier, there are exceptions, which is mostly appointed by the majority shareholder. This management takes certain decisions which the minority does not approve of. Now, if it does not approve of these decisions, by virtue of being in minority, it can't do much, because the majority principle will always apply. But however, in spite of being the minority, it does not mean that their rights can just be sort of trampled. So the right of fairness will still remain with them, even though they are in a minority. Although here we must draw a distinction. If I'm a minority shareholder of a company and I don't like a business decision on merits being taken by the management, it does not mean that for every decision I can rush to the court and tell the court that this decision is not right, then the other decision would have been better. It is only if I make out a case that the action of the management amounts to oppression and or mismanagement, then I can rush to court, and then the court will grant me any reliefs. So therefore, these two words, oppression and mismanagement, are critical. And the standard here is one of fairness. Now, one more thing we must keep in mind is that when the forum here under the old sections 397, 398 was the Company Law Board. Under the new Companies Act, it is the NCLT. Now, this is not a forum in which any evidence is led. So, unlike a suit, there's no trial here. Somewhat, obviously, the jurisdiction is much more limited than a 226, 227 writ petition. But somewhat like a writ petition, this is a petition of operation and mismanagement, which will be decided only on the basis of documents and affidavits. There's not going to be any evidence. So therefore, this jurisdiction, the court under this jurisdiction also has certain limitations. The court must not specifically enforce or give specific performance of any document. The court must not go beyond its jurisdiction. The court can only deal with operation and mismanagement as borne out by the documents produced by way of affidavits which are before it. So there are certain limitations, and you must make out that case of operation and mismanagement, or you must defend the case of operation and mismanagement by virtue of documents, like you do, like is often in the case in a writ petition. Now, like in any dispute, whenever any client comes to you alleging, that the counterparty or the partner or other person did XYZ, which is to their disadvantage, and so loss is caused to them, and they want to take remedial measures. First question that you ask is, what does the contract say? Because it is on the basis of the contract that you must live or die. So if the contract is clear, whatever has happened has to be judged against the contract. That is the standard. Now, in a minority-majority shareholder dispute also, the first question that you must ask is that what does the contract say? Now, in this case, the contract is most often the articles of association of a company. Articles of association is the governing document of a company. It sets out everything in detail. For instance, there will be an article which says that you must call a board meeting with a 21-day prior notice or a 14-day prior notice. It will say that you can appoint an independent director by so-and-so process. So as long as the articles of association are being complied with, are being followed, you can't make out a case of operation and mismanagement. So you must first and foremost ask that what is that particular article, which is like a contractual clause, what is that particular article of association that has been violated? This is the first question you must ask. You must you must start your inquiry by seeing whether there is violation or not of any articles of association. Number one. Number two, if, for instance, articles of association says that you must call a board meeting with a 21-day prior notice, and a board meeting, or it provides for an emergency board meeting, say with a 3-day or a 5-day prior notice, and the board meeting is called only with a 1 week or a 2-day prior notice, then you can perhaps say that, look, this has not been followed, therefore the board meeting has not been called in a valid fashion, and therefore the board meeting is not valid. Number two can be that the quorum of a board meeting, that it must always have an independent director, or it must always have directors of all groups. It must not only have directors present of one group. It should not be that, for instance, if there are two groups and both have equal directors on the board, one group calls a meeting with its directors and maybe an independent director and passes a resolution by majority. So there should be a quorum where every side is present, or both sides or more than two sides are present. So quorum, the timing of the board meeting, all these become relevant. Because what happens in these cases is that when basically a battle starts, like a war starts, and somebody is orchestrating events in a way at the cost of the other side, then to orchestrate those events, they need to take decisions in the board meetings. So it becomes very important to manipulate the board meeting, because then that side will want to manipulate the board meeting and manipulate the decision making, and then in the board meeting it will take the decisions which will be at the cost of the other side. So therefore these things may appear procedural, but they become very important. Quorum and advance notice, etc. So usually, first step is to check compliance with articles of association. Now, articles of association will also provide for how to remove a director. So, for instance, if there's a small private limited company, let me assume there are 3 directors, and 2 belong to one side and the other belongs to the other side, the third person. So, if I want to remove the other side's director, I will want to call a board meeting to remove that person, and I will want to do it in a way that I can have a majority on the board and remove it. Now, in this case, I may want to manipulate things and do things in a manner that my decision will pass will be approved. And the other side, when he gets a notice, he may run around and be like, and may want to even go to court for a stay on this board meeting, saying that this will not suffice. So therefore, we must always start. Basically, the entire case should start and end at the stage of articles of association. Now, we also spoke about the distinction between a board and the management of the company. Now, the management of the company will often has an incentive of reducing the board of the company to a rubber stamp. That whatever the management decides, the board simply approves. Now, therefore, before the disputes begin, or before the disputes reach a stage where a party has no option but to approach court, it is to prevent, as a preventive step. We have remedial steps in law, of course, where we go to court and seek remedy. But then, like in medicine, it's always better to have preventive steps, which ensure that things don't reach the stage where you have to go to court. So as a preventive step, the company must ensure, the shareholders, it is their duty. It is very important for all shareholders to always be active. You can't, just because you're not in management, you can't sleep over your rights. Because then invariably the other person realizes that you're not active, and then that will create an incentive for them to take steps which are to your disadvantage. So shareholders must be active, and a board must consist of independent people and people who represent all sides. So therefore, every board meeting that takes place, there must be an actual, it must not be what in Bombay we call a naam ke vaste board meeting. Where the minutes are just circulated, people sign it, have tea or coffee or whatever, and then leave. There must be application of mind in the board meeting. Things must be discussed, views must be exchanged, and that entire exercise must take place. Now, why will that exercise not take place? There are two reasons. One is that one side's directors are simply not interested, or that they've become compromised, where they've been told not to raise any issues. So therefore, for shareholders, it is very important at all stages to ensure at all times that board meetings are taking place in a transparent manner, that the minutes of the board meetings, which records the discussions which took place in the board meeting, are recorded correctly, and that basically they reflect exactly what happened. So, because the process of manipulation, it does not just happen one fine day. It happens over years, where one set of shareholders is sleeping, and suddenly it reaches a level which is so blatant, which is so apparent, that the other side wakes up and goes to court. But by that time, by and large, already damage has happened. And obviously, when the situation develops, it's not in the interest of the company, because the people running the company are fighting with each other instead of concentrating on growing the business of the company. So by that time, it's already gone to a stage where the company is not being benefited by any of this. Money is being spent on lawyers and everything. So therefore, the preventive steps are very important, where the primary focus must be that the board is independent of the management, and it acts as a check on the management. Now, taking a case where the board, for whatever reason, has failed to act as a check on management, and the board has become a rubber stamp, or the board is being successfully manipulated by one group of shareholders. In that situation, you have you have basically an open field for oppression and mismanagement. And now let's go to specific examples of how minority shareholders mostly are oppressed and mismanaged, and mismanagement takes place. First case can be where basically all shareholders should be entitled to the equal dividend, unless they are of the preference category. All ordinary shareholders should be entitled to equal dividend. So, for instance, if I'm a 51% shareholder and you are a 49% shareholder, if I declare dividend per share of X amount, as per my shareholding, I'll get the X amount. As per your shareholding, you'll get the X amount. However, I can't deny you your amount. So the moment I declare a dividend, I have to share your 49% and I'll take my 51%. Now, in the event that I don't want to share the income with you, I don't want you to get your 49%. I can resort to all kinds of means. I can not declare a dividend. I can increase, assuming I'm in management of the company and you're a minority shareholder, I can increase my salary and remove money through that route from the company. Number three, which is the worst, is that I can start stripping the company of its assets or of its business. For instance, I can, an order which should have come to the company, I can make sure that it goes to a friend's company or to my main army company or to another company. And that case, that business is not coming to the company. Now, this kind of practice will start showing in the revenue of the company, where every quarter the revenue is declining because business is being siphoned away, assets are being siphoned. So this is how these things start. Now, so this is basically a case of siphoning off or stripping off the assets of the company. Now, other than these, what I can do is that instead of siphoning off or changing the assets of the company, I can decide that I will shrink you, basically, shrink your shareholding. Or I will buy you up in a prejudicial manner. So one fine day, let's say that I decide that I will call a board meeting, and in the board meeting, I will have a valuation exercise done where I will value your 49% shareholding in an unfair manner and decide to buy you out. Now you will, so basically say, let's say you're a 49% shareholder, I will value your shareholding at X amount and say that I have an agreement and I'm buying you out. So the entire company will become mine. Now again, if that is not agreeable to you, but I am in control of the management and I'm in control of the board, and the board approves saying that so-and-so person can buy out the shares of so-and-so person, then again the minority shareholder will have to run to NCLT. Another thing that can happen in such a situation is that I can allot new shares and I can create fictitious entries in the books of the company, in the accounts of the company, saying that the company owes me so much money, which is more than what it actually owes me. Or in case it does not owe me anything, still there's an entry which says it owes me. And allot shares against that debt owed to me by the company. So my shareholding goes up and yours remains the same. So proportionately, my stake keeps on going up. So these are the typical ways in which persons in control of the management and the board decide to do things. They will either try to increase their shareholding, they will strip off your assets of the company, or they will try to buy you out in an unfair way, a minority shareholder. Now, control of the board. We've already established that control of the board is very important because that is the first sort of entity that serves as a check and balance on the powers of the management. And of course, the management is all powerful because it is in charge of business, it is in charge of accounts. So all kinds of things can be done. So it's very important for that to take place. So the first stage at which operation and mismanagement starts is at the board level. So, for instance, independent directors or directors belonging to a certain group are sought to be removed. By removed, I mean that on any fictitious charges, agenda is circulated amongst the members, the shareholders of the company, and said that so-and-so person, X and Y director, there will be a board meeting to decide on that person's removal. And then that board meeting will take place, and that person and a resolution will be passed that so-and-so person is removed. So first step in this battle is total control of the board or substantial control of the board of the company. Now, at this stage itself, it's very important for the disadvantaged shareholders to approach the court, saying that the board, so you must prevent manipulation at the board level. And the first, like for instance, if you get a notice saying that so-and-so person should be removed from the board, first thing you will do is you will rush to NCLT and you will ask for you will file an interim application in a petition under sections 241 to 246, and you will say that this meeting should not be held. That this meeting should not be held. That will be your interim injunction, that I should not be removed from the board of the company. Depending on the articles of association and whether the meeting has been validly called, the court will take a decision. But this is the first step. If you lose control of the board, by the time you reach the court or by the time your hearing takes place, it's possible that things have happened whereby your been compromised. Now, once you reach the court, usually the commonsensical view the court will say is that it will want to maintain some sort of a status quo. So it will not want anybody to be completely out. At the same time, it will not stop the functioning of the company. So usually what happens is the majority shareholder wants the minorities to be completely out. The court will not accept that. And the minorities want all kinds of preventive reliefs, which basically bring the functioning of the company to a standstill. Court will not want that also, because nobody wants the business, the core activity of the company to stop. So therefore, what happens in these situations is that the court takes, as usual, a middle ground, which is a fair ground, which sort of maintains the status quo and at the same time allows the running of the company to continue. Now here, when shareholders are locked in this dispute, where they are unable, there's no trust, there's a total breakdown in the relationship, there's no trust between the shareholders. Often there's also a very destructive ego angle, where in spite of the commercials being fair, for ego issues, two promoters, two warring parties, they simply cannot, reach a compromise. Although lawyers, I've almost always seen lawyers advise them to be rational and to see the commercial side and forget the ego battle. But that really boils down to the client. And it's in these cases very important to also realize commercially what is the best way forward. Because if two people can't work together, it's not like a court can make them work together. So therefore, now let's come to the exit. What is the exit once the battle starts? Exit, always, if two people can't work together, the exit means one buys out the other. That's it. That's the only way the exit can take place. Because otherwise, every day there's a constant tutu meme, and it continues in that fashion. And who's ultimately neither a judge or nor any third party is going to be able to make two people work together. It's up to them. So it now will come to the exit part once the dispute starts. The exit the court will always suggest is that if you can't work together, either the minority guy, you buy out him, or tell the majority to buy out the minority. And here, when we come to the exit part, the valuation becomes very important, because it must be fair valuation. Obviously, there's a certain price to the exit. Now, valuation here is always again a new battle, obviously, because each side has its own take on what is the fair valuation. So this battle again goes on for a long time, and valuation nowadays is complicated. You have the DCF method, you have the big four, KPMG, EY, etc., etc. You have their people who have their views on what the valuation is, and they make very, very complicated and lengthy reports on what is the correct valuation. But ultimately, no matter how complicated the reports are, there is a certain commonsensical angle to it, in terms of values. So there, now courts again take a commonsensical view, and they also see the posturing of the parties. For instance, it often happens that one promoter, one side says that I will buy you out at X price. That according to me is the fair price. And the other immediately gets up and says, you know what, I will buy you out at double the price you're offering. To basically show the court that, look, his price is so ridiculous that I am offering 2x, double of what he's offering me. And I'm ready to pay him that amount. So that also happens a lot. Eventually, the best way to find out the valuation is to have a third party, is to have an independent valuer. and even have somewhat of an um, third party evaluation by way of auction of some parts, some assets of the company, if agreeable to all sides, because that gives you the market price of the assets. So when you have this kind of a valuation exercise, the court can arrive at a report, and then finally the court will then give us, the court NCLT under 241 to 246 will give a comprehensive order, meaning will give a stepwise order saying that A can buy B out at X price as per the valuation report, or if B also has the option to buy A at X price as per the valuation report, and accordingly there will be a buying out process, and that will be an end to the dispute. Now, this is of course the legal end to the dispute. Parties are always free in any dispute to arrive at some kind of an understanding and settlement, which is not in the court's hands, but the courts always encourage, and parties can arrive at their own understanding. But in the event they can't arrive at an understanding, then how do we take it from the first step of an operation mismanagement petition to the exit of one side from the company? Basically, we have charted the entire territory from the birth certificate to the death certificate in that sense. So how do we start how the dispute starts, including what happens before the dispute starts over the control of the board, to the exit, end of the litigation. So this is basically the lifeline of a operation mismanagement dispute. It starts off with the boardroom battle. It ends up with parties going to court alleging that so and so person has not followed the articles, so and so person has not complied with this. There'll be allegations, counter allegations. It depends, because there's no trial involved. It all depends on the documents before the court produced by way of affidavits. The courts, depending on the documents, will take a view, will form a view, and on the basis of that grant preventive reliefs, which are in the nature of status quo. They will not allow the board to be completely changed. They will not allow the books of the company. Now, the books are also very important in this, because these are all commercial disputes. So the books of the company means that the company secretary becomes important also, because the company secretary of a company is the person who is ensuring day-to-day compliance with the provisions of the Companies Act. So if the books are cooked up, like we happened in the Gitanjali James case, where Nirav Modi and Mehul Choksi, the books were completely cooked up, and the largest creditor, which is Punjab National Bank, did not know about the books being cooked up and sort of was taken along for a ride, and there was a massive fraud. So in these cases, the management of the company has been completely sleeping or has been compromised because the promoter has been cooking up the books. The board has been sleeping, or the board has completely failed to do any kind of due diligence on the books being cooked up. And once that happens, the shareholders will always be at a loss. The shareholders who are not in on the game, who are not, party to the fraud, the innocent shareholders. So therefore, ultimately there is no, from a minority shareholder point of view, the only safeguard is constant vigilance and involvement and supervision of the affairs of the company. That's not to suggest that anybody should, become a paranoid watchdog, but what a prudent person would do over their assets, which is to ensure that the books are clean, have independent auditors, independent chartered accountants, trustable, credible chartered accountants, who will set up a particular standard, who will not be party to any fraud. Have independent directors who are in terms of integrity, their integrity is unimpeachable. So, and have company secretaries also who are credible. And once these people are appointed, auditors, chartered accountants, independent directors, company secretaries, also continue to constantly evaluate their performance to ensure that they're not compromised or that they're not negligent. So appoint the right people to serve as checks and balances, and then continue supervising whether they are serving that purpose. That is a preventive measure. And a remedial measure, once a conflict has arisen, like it happened in the case of Tata's, like it happened elsewhere, a remedial measure really is when there's a breakdown in trust. Now, it's a very, like for instance, in the Tata case, for whatever reason, the board lost confidence in the ability of Mr. Cyrus Mistry to run the affairs of the Tata. And they decided to remove him. Now, Mr. Mistry alleged otherwise. He said that this is an oppression and mismanagement, and these decisions have not been taken fairly, and they're all being controlled by someone who's outside the board. That is Mr. Ratan Tata. So this is all as per his orchestration. So now, in this type of a case, the court will see the court also, just because a minority shareholder gets up and says that, look, I have been prejudiced. That doesn't mean the court is going to buy it at face value. So in the Tata case, right up to the Supreme Court, the court said that it's the board's discretion to decide who will be the managing director and who will run the affairs of the company. And if the board in its wisdom has decided that it should not be Mr. Mistry and it should be N. Chandrasekhar, then so be it. We are not here to run the affairs of the company or to tell the company how to run its affairs. So that is how it also ends the other way, where the court does not accept the allegations. Then it will throw the minority shareholder out and say that it's okay, nothing so alarming has been brought to our notice, and the company should run the way it's been run by the board. So by and large, it's a narrow scope of dispute of operation and mismanagement. And again, I will end by saying one thing. Everything has to be judged against the articles of association of a company. Whether a particular action is oppressive and or constitutes mismanagement has to be judged against the articles of association of that company. Number one. Number two, articles of association of a company often are not entirely in compliance with the Companies Act. So you have certain statutory rights also under the Companies Act. In the event that any particular article is not in accordance with the Companies Act, obviously there can't be a contractual clause opposed to the law. So then you will have to challenge that article as being unconstitutional by virtue of being in violation of the Companies Act. So that is the second thing. And third, after articles of association, in some cases there are also shareholder agreements. Shareholder agreements may be relevant, but again, I'll repeat that this is not a case where trial goes on. This is not a court where trial goes on, as is the case in a writ petition. So you can't treat this like a suit. You can't treat this like a specific performance suit, that he agreed to do this with me and I am enforcing this contract. That is not the scope of this proceeding. So you must limit this petition. So you can't have oral agreements. You can't say he promised me this and he's not doing this and this amounts to oppression and mismanagement. Or you can't have agreements to enter into agreements saying that he promised me this and he's not complying with this. Ultimately, you must stop at actions which violate the articles of association of a company, and that's it.
Thank you so much, Mr. Mehta, there for your valuable insights on a very interesting legal topic, that is oppression and mismanagement of the Companies Act. So two quick questions, if you have the time, Mr. Mehta. Number one, suppose during the pendency of a proceeding under mismanagement or oppression before the National Company Law Tribunal or the Company Law Board, if suppose that shareholder or that director passes away, then can legal heads contest the matter on his or her behalf? And number two, the applicability of Limitation Act. If you could please elaborate.
Sure. No, good questions. Firstly, on Limitation Act, there is no limitation for oppression and mismanagement. So unlike a suit where you'll have 3 years for this and 12 years for that, here there's no limitation for act of oppression and mismanagement. So you can, when these disputes start, they go back a lot of years. You will say from 10 years he's been doing this or that. So that is as far as limitations concerned. Although of course, if you know something's have been happening for a long time and you don't do anything about it, it will create some amount of it will raise a question saying, what were you doing all this time? Number one. Number two, as regards if somebody passes away, then basically the shares, like any asset, will be inherited by the heirs of the person, and the company's register will have to strike off that person's name and enter the names of the heirs, which will be as per in current Bombay. You will require a probate petition from the High Court, or if you are elsewhere, then that's as per the will, and in case there's no will, then whatever as per your Succession Act. So that those persons will have rights to go to court. All they have to show is that we are the heirs, and that's it. And the court will look into that.
So thank you so much there, Mr. Nikunj Gupta, taking out time from your busy schedule on a working day. And I hope this presentation of yours will benefit all our viewers who are watching. So I hope all your fundamentals and concepts are clear. Our email is very well mentioned on the channel. So in case if there is any other query, feel free to write to us. We'll be more than happy to forward the same to our speaker, to our amicus for today's session, Mr. Nikunj Mehta from Bombay. And he'll be more than willing to help you or assist you on any of your fundamentals. So thank you so much, Mr. Mehta, once again. Thank you to all the viewers for your patience viewing and listening. And stay tuned. Next episode is on its way. Please stay home. Please stay indoors. Take care of yourselves. Venture out only when it's essential, and mask up when you venture out. So next episode is on its way. Please like, subscribe, and share my channel. It's goodbye for now. Thank you, Mr. Mehta, once again.
Thank you, Jay. Thank you,